Introduction to Statutory Research. 2 goals: knowing how to find the law and how to apply the law to legal problems, and learn how to use the law as a positive force for social engineering. American political system is both participatory and representative democracy. One of the rights of an American is the right to petition the government for redress of grievances. This right is the foundation of legislative advocacy, the right to propose legislation to the people's representatives in Congress. Christian advocates have added responsibility to zealously advance the cause of both legal and social justice. The duty of Christian advocates does not end when legal remedies are exhausted. Political remedies must be pursued where appropriate. For this reason, understanding of legislative advocacy is as important as understanding how to conduct legal research. To state it differently, both skills are equally important. Legal research could lead to a resolution of legal problems. Legislative advocacy could lead to introduction of public and private bills as instruments of social engineering. Let me stop. Oh, did I keep? What do I mean? Oh, you want me to keep going? Preliminary points. Primary authority versus secondary authority distinction. Before delving into research of statutory laws, keep in mind the distinction between primary authority and secondary authority. Primary authority is the actual law that is binding if applicable. In our context, statutes and regulations are examples of primary authority. By contrast, secondary authorities are designed to facilitate an understanding of primary authority. Examples are learned treatises and model codes. These are not binding on the court, but can have a persuasive effect depending on the professional or academic stature of the author. For example, the opinion of a distinguished professor of law will carry more weight than that of a professor of a different pedigree. Similarly, commentary written by a highly distinguished attorney will carry more weight than that of another attorney without a distinguished career path. Private law. First Amendment to the U.S. Constitution vests the citizens with the right to petition the government for redress of grievances. This is the constitutional basis for private law. Private laws are designed to protect or provide relief to individuals, corporate bodies, or a group of people. Here is a sample private law. There are 3 salient points I want you to know about private laws. First, private law is an extraordinary remedy. Its invocation is only appropriate after the exhaustion of other remedies. It's a remedy of last resort. The abuse of private law could lead to serious consequences, including a term of imprisonment. To this end, it's important to keep in mind the admonition of Apostle Peter in 1 Peter 4 verses 10. God has given each of you a gift from his great variety of spiritual gifts. Use them well to serve one another. Christian practitioners have a sacred duty to do all things to the glory of God. When the sponsoring of a private bill is abused, there are severe legal consequences, apart from the fact that it dishonors God. The second point to note is that private bills are not codified in the United States Code. They are collected as part of the statute at large. If you are looking for a private law, the source to use is the Statutes at Large collection. The third point to keep in mind is that private laws are enacted under the same procedure as public laws. There are three salient points I want you to know about private laws. First, private law is an extraordinary remedy. Its invocation is only appropriate after the exhaustion of other remedies. It's a remedy of last resort. The abuse of private law could lead to serious consequences, including a term of imprisonment. To this end, it's important to keep in mind the admonition of Apostle Peter in 1 Peter 4, verses 10. God has given each of you a gift from his great variety of spiritual gifts. Use them well to serve one another. Christian practitioners have a sacred duty to do all things to the glory of God. When the sponsoring of a private bill is abused, there are severe legal consequences, apart from the fact that it dishonors God. The second point to note is that the private bills are not codified in the United States Code. They are collected as part of the statute at large. If you are looking for a private law, the source to use is the statutes at large collection. The third point to keep in mind is that private laws are enacted under the same procedure as public laws. Public law. Before delving into a discussion of public law, it's germane to discuss briefly stages of lawmaking process. Slip law. Public and private laws originate as slip law. Slip law is the first print version of the individual law. Here is an example of a slip law. Take a close look at this slip law. Every slip law can be identified by its name, public law number, the statute at large citation, and date. Statute at large/session law. At the completion of each session of Congress, all slip laws for that session is compiled in the order in which they were made into a volume known as the statute at large. This is a chronological arrangement of all slip laws enacted during a particular congressional session. Arrangement of statute at large. Each volume is based on a congressional session. There are two sessions in each Congress. To make sense of how statute at large is arranged, keep in mind the following. Each Congress covers a period of 2 years. Each Congress is also divided into first and second session. Slip laws for each session is compiled as a volume of statute at large. For example, the 97th congressional session covers 2 years, 1981 and 1982. Slip law for 1981 is compiled as volume 95 of statute at large. Slip laws for 1982 is compiled as volume 96 of statute at large. United States Code. Introduction. Public permanent laws are codified into the United States Code. Excluded. Private laws and budgetary instruments. You will recall that the statute at large is arranged in a chronological order. In the United States Code, the laws are arranged by subject matter. All permanent public law in the statute at large are integrated with the relevant subject in the United States Code. Note that the emphasis is on the permanent public laws. For this reason, private laws are not published in the United States Code. Also, appropriation laws are not published in the United States Code. Appropriation laws are budgetary laws designed for a specific year. They are not permanent laws. Researching United States Code. The official source of legislation is the United States Code and is revised every 6 years. There are two non-official sources of United States Code: United States Code Annotated and United States Code Service. See examples of these versions below. United States Code, official and non-official, are kept up to date by pocket parts or supplements. Here are samples of pocket parts and supplements. You have to read the instruction at the back of the pocket part to know its status. For example, the pocket part to United States Code annotated below says it's replaced the 2011 pocket part. From this, we know that this pocket part is current through the end of 2011. Similarly, the supplement to the United States Code Service, the cumulative later case, and statutory service below contain an instruction that pamphlet issued before it should be discarded because it has been superseded. How to find legislation by subject matter. By general index. For example, use the general index to find accounted consolidation by following the illustration below. By popular name table. Use the popular name table to find Stevens Olympic and Amateur Sports Act by following the illustration below. Administrative Law Research. Federal Register. The Federal Register is the official medium for publishing information about the federal government. The Federal Register is published daily. It's cumulative. Example, the numbering is continuous. One of the main purposes of the Federal Register is to inform the citizens about proposed regulations so they could participate by making comments for or against regulations. If all things go well, the regulation is adopted. Notice of adopted regulation is published with effective date. No regulation is binding without the two notices: notice of the proposed regulation and notice of adopted regulation. This is democracy in action. Through the notice and comment procedures, public are able to participate in the making of regulations affecting them. Code of Federal Regulations. Code of Federal Regulations, CFR. Using CFR in print. Code of Federal Regulations is the official compilation of regulations that have been adopted. CFR is organized by titles, just like the United States Code. There are 50 titles. Each of these titles deal with specific subject area, such as the Postal Service in Title 39 and shipping in Title 46. Each title is reissued yearly on a staggered calendar basis as follows. Titles 1 to 16 is revised and issued on January 1st. Title 17 to 27 is revised and issued on April 1st. Titles 28 to 41 is revised and issued on July 1st. Titles 42 to 50 is revised and issued on October 1st. The easiest way to use the CFR in print is to browse by title. Alternatively, the index volume can be used.